जॉब में है, इसमें जो प्रेजेंट एक्टर हम लोग ने उनके नाम पर शूट करने के लिए आईए फाइल किया है, इसलिए वो केवल आईए पर
कंपनी है ना, आईए का क्या काम है?
आईए का जरूरत था, बाई नेम बना दिया थे, इस कोई तरह का कॉम्प्लिकेशन ना हो, इसलिए हम लोग ने आगे डाला।
बाई नेम किसको बना दिया?
डायरेक्टर सीएमडी साहब। तो ये मिनिमम वेजेस एक्ट का केस था, इसलिए किसी तरह का भी कोई कंफ्यूजन ना हो, इसलिए हम लोग ने आगे डाला।
आप ये बताइए,
जी,
you are for the company?
yes, I have on the company.
If a particular person has committed some offense or some उसका liability भी है क्या उस आदमी का?
मिनिमम वेजेस
नहीं, I want to know कि खाली कंपनी का liability फिक्स किया है कि साथ में co-extensive liability?
नहीं, कंपनी पर डाल दिया गया है।
Only company?
हाँ, कंपनी पर डाल दिया गया। मिनिमम वेजेस एक्ट का केस था, और चूंकि बाई नेम बना दिया है, तो हम लोग का रिस्पॉन्सिबिलिटी था कि कोई सा भी कंफ्यूजन ऑनरेबल कोर्ट में नहीं रहे। अब ऐसा आदमी जो आदमी आज जॉब में नहीं है, उस पर केस चले, तो वो पूरा मतलब कॉम्प्लिकेट होगा सिचुएशन, इसलिए आगे बढ़ा देंगे।
अरे क्या
For final disposal item 1, WPL 3639 of 2019.
I'm just waiting for Passover.
Passover, अगला कौन सा केस करेंगे? अगला कौन सा केस करेंगे? Tell me. If I give you Passover, I have to give Passover to everybody, no? Which case will I give? Next date तो नहीं होगा.
Because in this case, the relevant BSW has to argue the matter, and right now उसका एक फिक्स हो गया मैटर, बस वो करके वो आ जाएंगे, वो रेडी है मैटर।
Where for the respondent? फाइल कहाँ आपका? पढ़िए impugned order. Read the impugned order. Yes, we have shops and establishment act. It was held to be not maintainable. पढ़िए. Read it.
Page 36. The instant memorandum of complaint petition was filed under section 36(3) of the Bihar and Establishment Act, questioning the propriety, legality, validity, and implementation and bona fide of order of termination of service of component by OP number 2 from the service of OP number 1. It is contended that the complainant that he is an employee within the meaning of Bihar Soft M Establishment Act, hereinafter referred to as BI, and was appointed as assistant electrical engineer.
Assistant electrical engineer electrical engineer
In the Department of Electronics of the OP number 1 company. That originally the OP number 1 was Tata Steel Cement division, which was sold to the present company Lafarge India on 1/11/1999, and the services of the component was transferred to the new company without the consent, whereas the component wanted to retain its earlier management being employer. It is further stated that one Mr. Thomas Chief Executive Officer of the Lafarge India Limited, assigned the work and post of manager purchased to the company. It is further case of the complainant that on 12/12/2000 the management high officials called the complainant in its chamber and coerced him to sign the letter of resignation and drafted by management against his will. No complaint protested to this high-handed by the management, but could not succeed as the threat was given to publish the order of dismissal in the newspaper and to implicate in a false criminal case by the management with the help of local police. It is further contended by the complainant that alleged letter of resignation dated 12/12/2000 is illegal, nullified, and therefore the order of termination based on that illegal resignation is also bad in law, and the same be set aside and the complainant be reinstated in the previous job of the management with full back wages and other consequent benefits of service. It is a fact, this on the record, that the management has also appeared and has filed its written statement of fact WS in the same. The management was taken two important defense, which can be summarized as under. First of all, the first and foremost difference is that the complainant was directly and incidentally related to the job which was a part of the manufacturing process, and that being so, he was out of the purview of the definition of the employee as contained under the Act. Further, that being the case, the present complainant petition under section 26(3) could not be waived or such work. Secondly, that the resignation given by the complainant was his own plea and nowhere the management was adopted and pressure or coercive and placed to in the transference of resignation. At this juncture, I would like to state that it is apparent from the pleadings of the respective parties that domestic inquiry was not held as the element of misconduct was not.
Domestic inquiry was not held.
Yes. Domestic
It
inquiry.
is a case of resignation.
Yeah, they are saying that I've given the resignation, but facts of the case is that they have taken coercively. For that, we have filed earlier.
Is there any order of termination also? There is no order of termination.
No order.
Proceed.
Therefore, the court has directed and fixed up the proceeding directly to prove the case on merit, and thus it proceeded so. During the course of inquiry, both the parties have laid their respective oral and documentary evidence, which can be summarized up as under. The complainant B.V. Ramana had examined himself as a witness number 1, and one more witness, Ishwar Rao, was examined as second witness of complainant. That apart oral evidence, complainant has also adduced the following documentary evidence. Exhibit the application says, like the management was also adduced oral and documentary evidence which are as under. OPW number 1 and 2. The defendant oral evidence. The following documentary.
Just a moment. Your resignation letter is dated 12/12/2000.
Yes.
Correct. Which is that exhibit?
12/12/2000.
Yes. Which is that exhibit? Exhibit 1 is 13/12/2000.
Exhibit B. Exhibit B is the resignation letter which is caused to of this video. Page 43.
That's right. Like the management has also used oral and documentary.
Yes.
They have two witnesses, correct?
Yes. The aforesaid are the evidence on the basis of which the complainant wanted to prove its case of allegation against the management and seeking relief, whereas the management wanted to defend the same. After making calling of pleadings of both respective parties, the following issues can be framed: whether the complainant is an employee within the meaning of the Act to maintain the proceeding successfully, or it is elsewise; whether the letter of resignation dated 12/12/2000 amounting to the termination of service by management was signed by complainant under the force and out of coercion exercised by management. Now I take up the first issue for determination. It is true that as per the statutory provisions of the Act, only employee can file a complaint under section 26(2) of the Act for seeking relief. It is also clear from the provision of the Act that if someone is employed in the establishment who is engaged to work in the manufacturing process, directly or incidentally, would be out of purview of the definition of employee. If the relevant statute and would be a worker who can maintain a proceeding under the relevant Act. And Peru on the premised on the opposite legal principle which is undisputed, the contention of the management is that the complainant was not the employee under the Act, was one who was directly and incidentally both associated with the working of manufacturing process of the plant establishment and therefore would be worker not capable of maintaining the prevent complaint petition, previous complaint petition under section 26(2) of the Act, present complaint petition under section 26(2) of the Act. The pleading of the management as contained under paragraph 213 would reveal that the management categorically pleaded that the complainant was the manager purchase at the relevant time and was employed in the cement factory which has numerous machinery and process cement. The company
So the court has held that you were directly or indirectly engaged in the manufacturing process. You were the manager purchase, and you had to float the tenders and buy the goods. and everything.
they are saying that I was the manager purchase, so I was engaged in the manufacturing process, so I am not coming with the meaning of the employee.
No, you are connected to the manufacturing process
But
because that is a factory manufacturing cement. So what is the perversity in this order? Yes, Mr. Pati has
Second,
We have read the inclusion.
yes, madam. To sum up, madam, basically twofold grounds for holding it to be not maintainable. First, saying that he was connected with the manufacturing process, so it cannot be maintained. Second, said that in the pleadings, he did not make a averment that what clerical work he was doing. He simply said, though nomenclature was manager, but I worked as a clerk. These are the twofold findings, madam.
There is the pleading of the complainant should have
Yes.
been absolutely clear. Where paragraph number 16,
Yes, page 18, my lords,
there is no page 18.
in the writ petition.
Yes,
The
in the
Rocket
petition.
Annexure.
Annexure 1.
You read from the impugned order itself.
I was showing from the link. I'll read from
On the other hand, per contra, the pleading of the complainant about his nature of work was that being done.
Yes, page 40. On the other hand, per contra, the pleading of the complainant about his nature of job that was being done at the relevant time has been only said critically as of clerical in nature. This statement is well treated in paragraph 8 of this WS. The fact is that the term clerical in nature is the conclusion, and what was required to be pleaded was the breakup of the work that the complainant used to do, so that it could have been examined by the court as to whether the pleaded breakup and factorization of work performed by this complainant was actually of clerical in nature or was one associated with the manufacturing process of the factory. That being the pleadings of the respective parties on the nature of job, I find that the pleading of the management is crystal clear about the fact that the complainant was performing the work associated with the manufacturing process, and the pleading of the complainant is evasive, cryptic, and deceptive. The pleading of the complainant should have been absolutely clear, specifically whether his designation is of manager, which presupposes the exclusion of clerical work. Para 17, not only the pleading of the management, even the oral evidence has come on the record from the mouth of the complainant as noticed in paragraph 33 of his cross-examination that he was the manager of stores where spare or manufacturing were kept and sent to different departments on request. This evidence given by the complainant himself supports the pleading of the management that he was at least incidentally engaged in the manufacturing process of the plant. That being the fact position of evidence of the parties, I am convinced you that the complainant was performing the work of a manufacturing process and therefore was not an employee under the Bihar Shop and Establishment Act to maintain the complaint petition at hand. Secondly, this issue is decided again. Accordingly, this issue.
So what is it that you want to point out to show the perversity in the award?
Para A, my lord, is the statement wherein my lord he has said that he performed clerical nature.
What is clerical nature? What kind of job he was performing?
That is what is clear.
So you have ID Act, you go to ID Act. Under ID
My ID Act will also not be applicable because now once he says that I was a manager, so I will have some difficulty in going to
You
industrial.
do not know. You have your remedies wherever you want to go. But it is not in dispute that in the manufacturing process this is not applicable, right?
Yes, this is one judgment on that point, madam. Maybe to some extent may go against me. On behalf of establishment. So this actually deals with the issue. Now the interplay between the Bihar Shop and Establishment Act and the Factories Act that we have done. Though this is against the workmen.
The section is 26(2), right?
Yes, madam. Prior to that, the definition 26(2) read with the definition section 4. The effect has been considered by the Supreme Court, the same statute. Section 2, subsection 4.
I'm just coming.
Madam.
This establishment, is it registered under shops and establishment?
But I have pleaded that it is under the Shop and Establishment Act. That statement has not been specifically dealt or denied by me in the Act.
Denied?
I have said so that it is an establishment within the meaning of the Shop and
It is
Establishment
another
Act.
thing, registration. Registration is another thing.
Yes, where it says that the opposite party member was as establishment within meaning of the aforesaid Bihar Shop and Establishment Act and is a company registered under the company.
Company's registration is separate.
On
Because
that-
those who are running shops and establishment, they are under an obligation to get it registered.
Yes, they have.
What do you say?
You heard the court has said what we ought to say, no?
Registration.
No, registration is not there. Registration is no finding. Assuming it is registered and it is applicable, but not required. But the only point is, what was his job? He was in the purchase. Now, the purchase department means whatever is required for the manufacturing process. Now, if you look at the definition of worker in the Factories Act, which is by incorporation referred to an employee, so the incidental also in any way connected with the manufacturing process. It's a factory, undisputedly it's factory. You are sitting in the factory, regulating purchase. The clerical would rightly say
And by qualification, you are an engineer.
engine.
Because you were working as electrical engineer, assistant electrical engineer.
Purchase he was there, yes. In this company,
You
he was
were-
prior to that purchase.
Prior to
manager,
that, you
then
were
store
assistant
manager.
electrical engineer.
Right, but he is not a person who needs to be beneficially protected. That's all.
Assistant electronics engineer in engineering department, electronics department of Maharashtra.
So you were in the engineering department.
Yes.
You were
I
qualified
think
engineer.
In electronics department, he says I was employed as assistant engineer in electronics department of.
If a person is not an engineer, how will he be appointed as an assistant engineer? He has to be an engineer to be appointed.
Yes. At least technically,
I think yesterday or today only was I read a judgment on live law that the High Courts under 227 should be again not to reappreciate evidence and just
Friday.
Yes.
Friday.
Which judgment is that?
I'll just give it. High Court cannot consider DSS material considered by trial courts. Input this is notes. Vinay Raghunath Deshmukh versus Natwarlal Shamji Gada. I will just
Live law citation.
a live law citation is 2026 live law SC 424. And if your worship otherwise wants the neutral citation, 2026 INSC 416.
For the learned counsels appearing on behalf of the parties. This petition has been filed challenging the order dated 19/12/2018 in United Tenation 7 passed by learned Labour Court of Judicial in BC case number 5 of 2001, whereby the learned court has been pleased to dismiss the complaint filed by the petitioner under section 26(2) of Bihar Shops and Establishment Act 1959 by holding that it was not maintained. The learned counsel for the petitioner has submitted that the petitioner was earlier working as assistant electrical engineer in the company. Yes. In the Department of Electricity of the company, namely Messrs. Lafarge India Limited, which originally belonged to Tata Steel and was taken over by Lafarge India Limited on 1/11/1999. His specific case was that he was forced to resign while he was working in Lafarge India Limited in the capacity of manager purchase. The learned counsel has submitted that the learned court framed 2 points for consideration as to whether the petitioner is an employee within the meaning of the aforesaid Act of 1959 and whether the letter of resignation dated 12/12/2000 was under force and coercion. He submits that the second point was not answered as the first point itself was answered in against the petitioner by holding that the petitioner was not an employee within the meaning of the aforesaid Act. He has submitted that the materials placed on record have not been properly considered by the learned court, and therefore the impugned order is not sustainable in the eyes of law. He has also submitted that merely because the petitioner was engaged in purchase, in activity relating to purchase and handing over the purchase items for the purposes of manufacturing of cement. The same by itself will not bring the activity of the petitioner under the term incidentally engaged in the manufacturing process of the cement plant. He submits that the impugned order be set aside and the matter be remanded for decision on the merits of the case with regard to the designation. Right? That's all?
Yes, and Tara have said that basically working in clerical nature and no connection with the.
The learned counsel has submitted that it was a specific case of the petitioner that he was working he was doing the work of clerical nature and had nothing to do with the manufacturing process.
Directly or indirectly.
Directly or indirectly. The learned counsel for the respondent has opposed the prayer and has submitted that the petitioner was found to be incidentally engaged in the manufacturing process on the basis of the materials which were brought on record by the management. And the petitioner himself did not disclose as to what clerical nature of work he was doing. He submits that the Labour Court has considered the materials on record and come to a specific finding after appreciating the same, and there is no perversity in the impugned order calling for any interference. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in 2026 Live Law SC 424 equivalent to 2026 INSC 416 to submit that the
High Court cannot review or reassess. I've given you.
that High Court cannot review or reassess
the material.
the materials
That
on
was-
record
That was taken into consideration by the trial court.
that was taken into consideration by the trial. The learned counsel submits that the law is well settled that in absence of any perversity, there is no scope for interference in the order passed by the learned labor.
One more thing, no? It is not that clerical work in connection with, which is incidental or connected with manufacturing process is excluded. So anyone who is in clerical, assumed clerical but incidental to manufacturing process is also excluded.
The learned counsel has also submitted that even if it is assumed that the petitioner was engaged in clerical work, but there can be no doubt on the basis of materials on record that he was connected with the manufacturing work. And therefore, the impugned order does not call for any interference. This also you will rely upon 1978.
That should can rely upon my lord, because that explains the position of law, my lord. That I will not argue otherwise, but that actually to some extent it will go even against me. My lord.
We have got also the Rotas industry. That is on manufacturing process parasite. Both of us are relying.
No, you will rely upon.
Oh, very good.
The learned counsel for the respondent
That is
has relied upon the judgment passed by the Honorable Supreme Court reported in 1978, bracket close to SSC 140, paragraph 7 to submit that the very same provision were subject matter of consideration before the Honorable Supreme Court, and it has been held that the persons who are employed in any other kind of work incidental to or connected with the manufacturing process or the subject of the manufacturing process are excluded from the purview of applicability of Bihar shops and establishments.
And most importantly, Supreme Court actually says raw materials used in the manufacturing process for producing paper and various products undoubtedly will be subject to. So that means raw materials purchase is in purchase.
He submits that the Supreme Court has also held that the purchase of raw material in the manufacturing process is integrally connected to the manufacturing process. After hearing the learned counsel for the parties, and it is not in dispute that it has been well settled by the Honorable Supreme Court that that any kind of work incidentally to or connected with the manufacturing process or the subject of the manufacturing process are excluded from the purview of, from the applicability of the Bihar Shops and Establishment Act 1959. The paragraph 7 of the judgment passed by the Honorable Supreme Court is quoted as under. This court finds that the learned labour court has considered all the materials on record and held that on the one hand, the petitioner did not disclose as to what clerical work he was doing, and on the other hand, the management had brought on record the work being undertaken by the petitioner and ultimately found that the act of the work of the petitioner would at least come within the purview of incidentally engaged in the manufacturing process of the plant. It is not in dispute. It has also been considered that the petitioner was engaged in the purchase of the articles to be used in the manufacturing process of cement. This court finds that the learned court has meticulously examined the materials on record and no perversity in the matter of appreciation of the materials on record to be pointed out by the learned counsel for the petitioner, calling for any interference under Article 226 of the Constitution of India. The law is well settled that in absence of any perversity, there is no scope of reappreciating the materials and coming to a different finding. Once in the matter of orders passed by the learned labour court, the judgment of the Honorable Supreme Court, the big paragraph I just posted.
15 and 16. Yes, sir. 16 and 17. 16.
The Honorable Supreme Court in the aforesaid judgment has held in paragraph 16 that in a matter of that in a writ application, it is not open for the High Court to review or reassess the materials that was taken into consideration by the court while passing the impugn order.
And they cited the Rajkumar order which says High Court is not an appellate or a
as the High Court is not an appellate court under Article 227 of the Constitution of India. It is well settled that so far as the orders passed by the Labour Court is concerned, this court acts in supervisory jurisdiction and there is no scope for reappreciating the materials in absence of any perversity. Accordingly, this court finds no merits in this petition, which is hereby dismissed.
One thing that very valid for the registered order. There, the witness, the management witness has admitted in deposition that he has been registered under stock. That I have also pleaded in
Item 2, WPL 410 of 2023.
Acceptance was by your lordships in the order dated 16 to 24.
Yes, I see that. What do you have to say more?
So the only thing is, so the case is there was a repartition proceeding where your certain increments are required. Now you have criminal cases going on with respect to defalcation, which was not the charge. Now if he is convicted in a criminal case, that because the language used in 4.6 is that any commits any misconduct involving any offense is not monitored. So defalcation will always be monitored.
with respect to an offence which took place while he was in service. And if he is convicted, then naturally he will not be entitled to bail.
Is it automatic? Or there has to be a notice? There has to be a procedure under the payment of gratuity
The
act.
issue is whether he also during the pendency of the departmental criminal trial, whether the amount can be kept. It has not been forfeited. Withholding is not there in the concept, but the
There is no
judgment
such
has-
concept of withholding.
withholding, but that has devolved from the judgments of the Honorable Supreme Court. First judgment, Your Lordship, was Your Lordship that Ramotar Chaube. Thereafter,
Where is that?
22/1/12 SEC Lordship has taken note of.
Ramakta Chaube is 2020-18 SCC 71.
SEC, that was my larger bench where it is said that if a departmental proceeding is pending, management can withhold. That was only with respect to departmental proceeding. Now that has been also extended to criminal trials in 2022/1/12 SCC 104, which says that this principle will apply also in cases where he is pending. Otherwise, also a person, for example, border scam. People have committed the scam. Why, if they only because they retired before conclusion of trial, then also they will get everything. Ultimate conviction will only.
There is no finding that you have suffered any. There is no finding that you have suffered any loss.
Also, that is the finding in the charge sheet by the CBI.
No,
That there was a defalcation of 44.
just a moment. Here, so far as the
So there was a shortfall of gold to the tune of 152.
where is the order by which the it was up withheld? Where is that order? It must have been withheld by an order. Where is that order?
It is not on record. But if you also see the improved orders also,
It is not on record. It's a primary order. Where is it?
that is not on record. It is application and both the orders are.
There must be some discussion in the improved order.
Yes. Lordship, can you see para 4
Para 4?
at page 36? The original one.
36. Yes.
The applicant Samudayal Dhruva, son of late such and such, resident of such and such, controlling and abuse oral evidence. He was appointed on 182 superannuated as a chief manager. He applied for the opposite party for payment of gratuity amount, but the opposite party has not been informed whether rejected the claim of the payment of gratuity due to pendency of an inquiry. That he was appointed as project officer in PS and handed over the charges and such that the incident had happened by 21 months from handing over the charge. The inquiry has already been concluded and it will impose a penalty of reduction of money. The opposite party has already deducted 1 increment from the salary. The inquiry officer has said nothing on the gratuity amount in the inquiry. That it is the same charge sheet. Another 2 persons, equal and such has received their gratuity amount from the inquiry. He has filed the case for payment of gratuity against amount which is deposited before the controlling council. That only a CBI case pending against him. He does not want interest on gratuity during the circumstances. So he admits that there is a criminal case.
No, it is merely because the withholding of gratuity, separate order was passed with respect to criminal case. You withheld the gratuity. There are 2 persons you have released also in their favor, identically placed. And so far as your findings are concerned, have you held that he is guilty of moral turpitude?
No, there is a criminal trial pending against him.
May be pending. May be pending. But for that you have to pass a separate order withholding his gratuity. Because it was withheld when the inquiry was pending against him. Right?
This is what he has said. We have taken a ground, Your Lordship. Your Lordship sees our case. Your Lordship, can you come to page 30?
And does your rules, the service rules provides that you can withhold gratuity?
Service rules provide that if a person is convicted in a criminal case involving moral turpitude, gratuity can be forfeited. But if that Supreme Court says that if a criminal trial is pending, and if it is because that involves
You
moral
see,
turpitude
criminal trial is pending.
with an allegation of defalcation.
No, whatever it is not automatic. You have to pass a separate order that because your criminal case is pending and therefore your gratuity is withheld. Here in this case, that is not the matter. You withheld his gratuity when the inquiry was pending.
No, we have not withheld also. What we did was, we deposited it with the controlling authority saying that this trial is pending, kindly don't disburse it to you.
That is all the more serious. You have deposited it and you do not want him to give.
No, we-
It is, you see, if you had withheld it, you would not even have deposited it.
No, we have deposited with a request that don't disburse it.
No, why? How can you control the authority that don't disburse it?
Because a criminal trial involving moral turpitude.
No. Then you should not have deposited it because there is no liability to pay. You are doing two things at a time, right? Once you are depositing it and then you say no interest would be payable, correct? Right? You are trying to ensure that no further interest is payable on the gratuity amount, and at the same time you say that it should not be disbursed. How can you have it both ways?
Lordship would consider the case. If this, Lordship only come to our show clause, Lordship, that page 2, annexure 2, page 2.
First, I would like to see the order of punishment.
So that is also not.
Annexure one by one.
Annexure 1 is there.
One by one is there.
Yeah, annexure 1 is there.
You read the finding.
Yes.
Page 29.
What is the finding? Yes, bottom. Page 28, bottom.
Yes. Whereas after careful examination of the memorandum, inquiry proceeding, inquiry report and final representation of Sri Durga on the disagreement note dated 19/3/2018, the relevant facts and circumstances of the case, the other side is of the opinion that Durga is found to be guilty of the charges leveled against him in the memorandum referred above. In contention of Durga has, as accepted by the IA, that surveyor has placed the MB during the period of charge officer as project officer after his signature and manager's signature in the office with flag, and the charge officer, that is the then project officer, has signed seeing their signature on trust. Is not acceptable because as per the details of the measurement book duly signed by Durga, it is evident that there did exist a coal stock shortage of more than 152,489 metric tons as per the record of the same measurement book on 1/11/2009. Sri Durga had signed the same measurement book for so many months. Sri Durga then, project officer, had also the responsibility to have the proper reporting system of production as per the existing norms. Any irregularity done by the colliery surveyor in measurement book, in which the project officer has signed regularly, and responsibility lies on the project officer also. Whereas after going through the facts and record, I, Chairman, Managing Director, I have considered ends of justice ruling imposing a reduction of lower stage at the current time. So now here in the departmental proceeding, the charge was that he signed a measurement book without acknowledging that there was a shortage. But the criminal trial, the charge sheet has been submitted by CBI.
We don't bother about it, nothing is there on record. We do not know what is the CBI inquiry.
Also, we have stated in the
Your statement is of no consequence because we are into 226 or 227 against the order passed by the authority.
Also, the admitted facts of the cases, I just admitted fact of the cases that a criminal trial for offences involved which are of grievous nature and involve moral turpitude is pending against the delinquent.
What do you mean admitted fact?
That a
You
criminal
show
trial-
it from the record that it is an admitted fact.
Also, I showed from para 4, that is the submission made by the workman himself. He also admits that yes, a criminal case is pending against him. Nobody says that it is not pending. Criminal case instituted by CBI is pending. That is in his. He never disputed that no, I am not an accused in the criminal case. Rather, he also admitted the fact that he was in custody from 26/11/2014 to 23/8/2016.
I just want to know one thing.
Yes.
The appropriate remedy was the disciplinary authority proceedings
So
where he could have quantified the loss.
one thing, I have
There is no quantification of loss.
Also, there is a departmental proceeding. I am saying also the facts as it stands on some date. There is a departmental proceeding with a punishment of withholding of money.
That too
Yeah.
without
Yes.
any cumulative.
Now, Your Lordship will just, if the criminal trial had been concluded while he was in service and he had not concluded, I put a question to myself whether he could have continued in service, saying that no, I had been given only one plea. Conviction is a separate misconduct.
Does the conviction in a criminal case automatically forfeits the gratuity?
Yes, if a person is convicted, Lordship can is and this is section 46.
Payment of gratuity.
Notwithstanding anything contained under subsection 1, the gratuity of an employee whose services have been terminated for any willful act, omission, negligence causing damage, loss, or destruction of property of the belonging to member shall be forfeited to the extent possible. This is one part. B.
I want-
Gratuity.
Section
Yes.
4.
4.6. First is Lordship, what Lordship was followed from Lordship quantification of the loss. Notwithstanding anything contained in subsection 1, the gratuity of an employee whose services have been terminated for any act, willful omission or negligence, causing any damage or loss to or destruction of the property belonging to the employee shall be forfeited to the extent of loss or the damage or loss so caused. Here there has to be a quantification. B. The gratuity payable to an employee may be wholly or partially forfeited. Roman 1. If his services of the employee has been from B, there is no quantification of loss.
You read Roman 1 and 2.
Roman 1 and 2. If the services of employee has been terminated for his righteous or disorderly conduct or any other act of violence on his part, or if the services of an employee has been terminated for any act which constitutes an offence involving moral turpitude. So this will happen only when there is a conviction by a trial court, provided that such offence is committed by him in the course of employment. Now, Lordship, there will be a difference between a non-executive and an executive. In view of that, Lordship, Ramadhan Chauvin judgment, Lordship, the workmen or the non-executives, there is no provision to Lordship terminate him or take any action or initiate any proceeding after post-retirement. With respect to executives, like the present respondent, Lordship, that has been discussed by the Honorable Supreme Court, same set of rules.
The moral turpitude, still the withholding of gratuity will be relatable to, non-payment of gratuity will be relatable to the loss suffered.
If a person is convicted for, if he has been found to have committed an offence involving moral turpitude.
You see, it may be wholly or partially forfeited.
Yes.
It is not that compulsorily once a person is convicted, पेन चोरी किया तो भी forfeit हो गया. नहीं पेन चोरी किया तो भी forfeit हो गया. पूरा institution चोरी कर लिया तो भी forfeit हो गया. Story is same. So therefore, what is important is the quantification of loss.
I put a question to myself. If a person is convicted under 498, offence involving moral turpitude,
I just want to know.
so there will be,
from you.
therefore, why wholly and
No,
partially
I just want to know from you
Yes.
that in order to quantify,
So we have to wait for the judgment of the trial court.
then why did you deposit the amount?
But
You
we
are-
have
you are-
deposited informing
No,
that
you are stopping them from getting the fruits of interest also. From who will pay for the interest?
if we have
Will you pay? Will you pay? If he succeeds, will you pay the interest? Tell me. You will not pay, no. We know that you have deposited the amount to curb the running of interest, and you will not let them. If you were so sure that you have not to pay, then you should have forfeited it. You have not forfeited it.
No, so forfeiture cannot
You
take
see,
place.
you have not even withheld it. You have deposited it in the court. It is not a case of withholdment because you have voluntarily deposited
We
it.
have deposited it with informing the controlling
It is
authority.
immaterial. It is immaterial. You have deposited it, right?
Then
You have not withheld it. You have deposited it.
Situation, if Your Lordships, it has been deposited and disbursed and ultimately convicted.
We do not know. You should not have deposited.
So in all cases, we deposit it informing that this is the.
You can't have it. Siddhas, you can't have it both ways. Running of interest you will curb, right? And you will wait for the trial to be over. And maybe you will wait till the matter is decided by the Honorable Supreme Court. Correct? And then who will compensate the employee for this period? Because the running of interest is now curbed. You have to bear the risk also. If you do not want to pay, you bear the risk of the running interest. Isn't it? You can't have it both ways. What is the reason cited, and show me those two judgments which we have mentioned it. What is the reason cited by the learned appellate court?
Said that 4.6 there is no such provision that without termination it can be.
Where is that finding?
Also to hand it out to para 38 para the judgments have been para 9 onwards. Para 9 section 4.6. Para 9 Your Lordship, if section 4.6 has been discussed, therefore para 10, the opposite parties counsel refer to the judgment of the Honorable Supreme Court in the case of Chairman cum Managing Director Mahanadi Courtfield Ravindranath Chauve, wherein it held that it is a case where the appellant, the charge sheet served upon the respondent clearly. There are serious allegations of misconduct alleging dishonestly causing coal stock shortage amount of such and such crores and thereby causing substantial loss to the employer. If the charge is proved and punishment of dismissal is given thereupon, the provision of section 4.6 of Procedural Gratuity Act would naturally get attracted, and it would be within the discretion of the appellant to forfeit the gratuity payable to the respondent. As a corollary, one can safely say that the employer has the right to withhold the gratuity pending departmental inquiry. However, as explained above, this course of action is available only if a disciplinary authority has necessary powers to impose a penalty of dismissal upon the respondent after his retirement. Having regard to our discussion about Jaswant Singh and Supra and Ramlal Bhaskar's Supra, this issue needs to be considered authoritatively by a larger bench, and therefore we are approved. Therefore, also this judgment, the larger bench judgment has come out. It is apparent the Honorable Appeals Court on this judgment referred to reconsider the judgment of Jaswant Singh Gill versus Bharat Coking Coal Limited and others by a larger bench. Hence, the Apex Court's judgment in Jaswant Singh Gill versus Bharat Coking Coal Limited and others should prevail until negated by larger. It has already been negated. The Honorable Ahmedabad.
Which judgment? You are not giving me a copy of the judgment.
Yes, yes.
May I just submit your question? The judgment and the paragraph.
Just a moment, let me just read the judgment.
One judgment that is 2052. In this case, also we can see 2022 judgment.
I want to see 2018 also. Where is 2018?
Yes.
You just read para 30 of the judgment that you have seen.
Para 30. Para
30.
In the present case, separate departmental proceedings have not been concluded within the given time. The state in its wisdom has deemed it appropriate to await. So that is the distinguishing factor. But
It is a very material factor. Please read it completely.
the state in its wisdom has deemed it appropriate to await the outcome of the criminal proceedings. The result of this would mean that state would still be empowered to dismiss an employee from service based on the conviction of in the criminal case. State cannot have an opportunity to have a separate departmental proceeding even if the acquittal takes place. If this was where the intention, departmental proceedings should have been concluded in a stipulated time. We are conscious of the fact that mere acquittal in a criminal case would not imply that no action can be taken by the departmental proceeding. However, the choice was with the state government as to whether they would be like to hold a separate departmental proceeding or go by the final view of the criminal court. The latter is naturally based not preponderance of probabilities but burden of proof beyond reasonable doubt. It is the latter course the state has followed. Thus, an employer is entitled to all benefits and right not to be now dismissed from service till new if the criminal proceedings conclude in the favor of the employee. However, where the proceedings have been concluded against an employee and conviction upheld, it cannot be said that department would still require to pay all the retirement benefits. Department can also pass an order of dismissal based on solely on the.
Now you tell us, after this person has retired,
Yes.
you have conducted a disciplinary proceeding,
Yes.
imposed a punishment. On the same set of facts, there is a criminal case pending. After his dismissal, after his retirement, will you be able to dismiss him?
Yes, that has been held in Mahanadi conference. Same set of service is same rules are applicable. Said that these rules permit us to continue with the department.
No, continuation of departmental proceeding is another thing.
To take disciplinary action even if a person is convicted.
Even if he has been already held guilty in a disciplinary, there are, you see, now for the same set of
So I
charges.
take a agree that if a person has been exonerated in a departmental proceeding.
Yes.
Then it is the case if a person is exonerated in a departmental proceeding, subsequently he is convicted in a criminal case involving moral turpitude. Conviction itself under the rules is a separate misconduct.
That's right. But can you dismiss a person
Yes,
after retirement?
After retirement,
Show me the rule that you will dismiss him after retirement, even if he is exonerated in a disciplinary proceeding.
judgment said, that was against BCCL only.
No,
Judgment said that we cannot.
You see,
Once he has retired, the employer relationship.
Mr. Das, you are understanding what I am saying, but you don't want to spend.
No, I will just
You
explain.
see, there is a departmental proceeding and a criminal case arising out of the same set of facts, right? In the disciplinary proceeding, you impose him a punishment.
But I take it
Just a moment.
Yes.
He suffers that punishment, right? Now, in the meantime, a criminal case is also pending, and he retires. He attains the age of superannuation. Now, thereafter, he is convicted in the criminal case. Now, will you terminate him?
He will be deemed to have been terminated.
Deemed.
What?
How? Under what provision of law? Because you have not kept your right to continue with the departmental proceeding, nor you have kept it reserved that after the conviction you will take care of him. That is not the
Once
case.
the departmental proceeding was on a particular set of charges, say X was the charges. Conviction in a criminal case, so that is what I was trying to clear. I am not clear. Conviction in a criminal case, irrespective of involving moral turpitude, is a separate misconduct.
That's right. That is why I want to know, after the person has already attained the age of superannuation, can you initiate a fresh departmental proceeding on the basis of his conviction?
Yes.
Show me.
So
Show
I'm
me.
just getting the judgment by mistake. It print out has been left. I'm just getting it. 2020 volume 18 SCC page 104 page 71.
Show me. आप अपना जजमेंट नहीं लेके आते, इतना बिजी मत रहिए भाई.
नहीं जजमेंट था, जजमेंट मार्क भी किया हुआ था, लेकिन कॉपी
Have you got a copy?
Of that judgment.
You are also not aware.
I'm having the other judgment of this honorable court wherein it has been settled.
You said that
that
it is.
pending of
You don't see the previous orders. It is mentioned in the previous order, and you don't get the judgment. What can I do more for you?
I have that in my list. I have that.
But I don't have it.
Because
No, it is recorded in the previous order.
I have that in my eyesight, Your Lordship, but not in the hard copy. I am having the judgment on which I am relying upon, Your Lordship.
Which is that judgment?
Yes, this is the judgment of this honorable court itself settled by the division bench of this honorable court, wherein exactly the similar issue was decided. This is the first judgment is of the writ court and the second is the LPA court, wherein the issue is that whether the pendency of the criminal case can empower to withhold the gratuity. Your Lordship, may writ petition para 7 में kindly come. Para 7, Your Lordship, internal page 4, last 3 lines it says, the legal issue to be decided in the instant writ petition is whether pendency of the criminal case can be a bar for non-payment of retirement benefit including gratuity, pension, group insurance and leave encashment. The decision is that relying on various judgment of the Honorable Supreme Court, ultimately in para 14, Your Lordship, may kindly turn. Internal page 6. May I?
Yes.
The same view was reiterated in the case of Jitendra Kumar Srivastava Supra, wherein the Honorable Apex Court has held that in absence of any specific rules, pension being as a right in property cannot be withheld and the same is impermissible. It was observed that a person cannot be deprived of pension without the authority of law, which is a constitutional mandate enshrined in Article 300A of Constitution of India. It follows that attempt of the state government to take away a part of pension or gratuity or even leave encashment without any statutory provision and under the embargo of administrative instruction cannot be compressed. As a sequitur of the aforesaid rules, guideline and judicial pronouncement, this court take no other view. And then this was challenged before the division bench of this honorable court. It is decided on 25/8/2025, para 31 onward. Internal page 5, para 31 onward, Your Lordship. It is not in dispute that respondent number 1 served the university as a lecturer and thereafter, while she was posted a member of the Jharkhand Public Service Commission, as many as 6 criminal cases came to be lodged against her by the Vigilance Department. Out of these 6 cases, she came to be acquitted in 3 cases, while the other 3 cases are still pending adjudication, but the fact remains that the respondent number 1 was never convicted. Even her suspension order passed from time to time came to be revoked. Therefore, the only issue which was required to be decided by the learned writ court was as to whether pendency of a criminal case can by itself be a bar for non-payment of retirement benefit, including gratuity, pension, group insurance, and even
Yes, we have seen this. So there has to be a specific rule.
There has to be a specific rules, Your Lordship, and in this they have also quoted one rule of there, wherein it is stated, Your Lordship, that if a departmental proceeding is pending, then only he can withhold, not a criminal proceeding, Your Lordship. Moreover, section 4, subsection 6 says that he has to be terminated on the ground of moral.
Question number 1, Mr. Das.
Yes.
Whether it is permissible in law for the employer to withhold the payment of gratuity even after the employee has attained superannuation from service because the pendency of the disciplinary proceeding against him. In this case, the disciplinary proceeding has concluded. Now my question is that can you now start a fresh disciplinary proceeding? It was your choice. You could have waited for the conviction. You could have waited for the conviction, keeping it open to you that in spite of superannuation, you will continue and give him a charge on the that is permissible in law. But you are not chosen to do that. Now you want that for the same charges, not, you see, for the same charges there is a disciplinary inquiry and criminal case. For the same charges in the disciplinary proceeding, punishment has been imposed and suffered. Now for the same charges, having been convicted in a criminal case, you will initiate another disciplinary proceeding.
There is no requirement of initiation of another departmental proceeding.
It
If
will
a
be
person,
automatic.
no, so if a person is convicted in a criminal case, so automatically he, Lordship,
No, it is not, this is not one and the same.
Lordship, this judgment, I'll say why, Lordship, I was
You
relying
read, you
on that.
read, you read. Whatever you want to read from this judgment, you read.
Lordship, first, Lordship, can you come to para 41? Jaswant Singh bill has been overruled.
Para 41.
Yes.
Let us have a look at it. Yes, read it please.
We are unable to agree with the decision rendered by
No, no,
Jaswant
read
Singh.
from, yes, just one second. You read para 40 first.
40.
Hmm.
We find it difficult to agree to the decision of Jaswant Singh Gill as rules hold the field and are not repugnant to the provisions of Payment of Gratuity Act 1972. This court held that the rules are not rules could not hold the field as well as they were not statutory. Thus, the effect of the rule provides for deeming legal fiction as if they had continued in the service notwithstanding crossing of the age of superannuation was not considered. Apart from that, the validity of Rule 34.2 and 34.3 could not have been decided as it was not in question in the said case. The controlling authority and the appellate authority ordered the payment of gratuity. The main ground employed was that in the order passed by the departmental authority, the quantum of damage or loss caused was not indicated, and it was not the case covered under section 46A or 46B. A writ petition filed by the employer was dismissed. However, the intra-court appeal was allowed, and it was opined that controlling authority could not have gone into the validity of the dismissal order and forfeiture of the gratuity, since it was not an appellate authority of the disciplinary authority imposing punishment.
Just come again.
This
Just the controlling authority and appellate authority ordered the payment of gratuity. The main ground employed was that in order passed by the departmental authority, the quantum of damages or loss caused was not indicated, and it was not the case covered by section such and such. A writ petition was filed by the employer was dismissed. However, intra-court appeal was allowed, and it was opined that the controlling authority could not have gone into the validity of the dismissal order and forfeiture of gratuity. So here also the disciplinary proceeding was taken to a logical end.
therefore, when the inter-court appeal was allowed, in favor of the management, Jaswant Singh Gill went to the Honorable Supreme Court, and his writ was allowed, his SLP was allowed.
You read para 39, what happened in Jaswant Singh Gill?
Yes. In Jaswant Singh Gill versus Bharat Booking Co. Limited, it was held that the provision of section 46 of the Payment of Gratuity Act 1972 would prevail over non-statutory BCCL, a subsidiary of Coal India Limited, Rule 34.2 and 34.3, and the provisions of Payment of Gratuity Act were considered. It was held that even if the disciplinary inquiry was initiated before attaining the age of superannuation, if the inquiry attains the age of superannuation, the question of imposing a major penalty by removal from service, a removal or dismissal from service would not arise. Once the employer has retired and his services have not been extended for the purpose of imposing punishment, the major penalty could not be imposed. It was also held that the rule framed by the Coal India Limited as non-statutory rules, and in view of the provision of section of Payment of Gratuity Act, they cannot prevail. In the said case, the order of dismissal was passed after the age of superannuation. It was found that misconduct did not cover the grounds mentioned under section 46A for recovery of loss, nor it was the case of misconduct in which gratuity could have been withheld only or partially in the exigencies as provided under section 46B. Now, Your Lordship, you can see section para 41.
Yes.
We are unable to agree. That was the view taken by the Honorable Supreme Court. We are unable to agree with the decision rendered by Jaswant Singh Gill case inter alia for the following reasons. 41.1. The order of termination was not questioned, nor the authority under Payment of Gratuity Act had the jurisdiction to deal with it. the validity and enforceability and values of service rules 34.2 and 34.3 were not questioned. The controlling authority under the Payment of Gratuity Act 1972 had no jurisdiction to go into the legality of the order of the disciplinary authority. The scope of the case before this court was confined to the validity of the order of controlling authority and the question which could have been dealt by the controlling authority. No factor is caused on the efficiency of rules by section 4.1 and 4.6 of Payment of Gratuity Act 1972. The rules need not be statutory to have efficacy as they were not repugnant to the Payment of Gratuity Act 1972. This rule did not this court did not consider the scope of provisions of Payment of Gratuity Act and provisions of Rule 34.2 provided legal fiction of employee being deemed to be in service after his superannuation. The controlling authority had no jurisdiction to deal with Rule 34.2 and 34.3 and to pronounce upon the validity of the dismissal. Thus, observations may travel beyond the scope of proceedings, cannot be said to be binding, and cannot constitute a ratio with respect to continuance of departmental proceeding after superannuation and what kind of punishment can be imposed by the employer. The jurisdiction of the authority was only to consider the payment of gratuity under section 4.6 of the Company Act. Thus, we overruled Jaswant Singh case. Now, your Lordship, can you come to this? Para 47. Thus, considering the provisions of rule,
उसके ऊपर से पढ़िए the mandate of you read para 46 and then 47.
Several service benefits would depend upon the outcome of an inquiry, such as considering the period during which inquiry remained pending. It would be against the public policy to permit an employee to go scot-free after collecting various service benefits to which he would not be entitled, and in the event of superannuation cannot come to his rescue and would not amount to condonation of guilt. Because of the legal fiction provided under the rules, it can be completed in the same manner as if the employer had remained in service after superannuation and appropriate punishment can be imposed. Various provisions of Gratuity Act discussed above do not come in the way of the departmental inquiry, and as provided under section 4.6 and 34.3, Rule 34.3 of the case of dismissal can be forfeited wholly or partially, and loss can also be recovered. And inquiry can be continued as provided under the relevant rules, as it is not provided under the Payment of Gratuity Act 1972. And that inquiry shall come to an end as soon as the employee attends the end of superannuation. We reiterate that Act does not deal with the manner of the disciplinary inquiry. It contemplates recovery from or forfeiture of gratuity wholly or in part as misconduct committed, and does not deal with punishments to be imposed, and does not supersede Rule 34.2 and Rule 34.3 of the CDA rules. The mandate of Section 4.6 of recovery of loss provided under Section 4.6a and forfeiture of gratuity wholly or partially under Section 4.6b is furthered by Rule 34.2 and 34.3. There cannot be any dismissal after superannuation. If there cannot be any dismissal after superannuation, intendment of provisions of Section 4.6 would be defeated. The provisions of Section 4.1 and 4.6 of the Payment of Gratuity Act 1972 would be given purposive interpretation and no way interdict holding the departmental inquiry and punishment to be imposed is not a subject matter under the Act.
Now let us see what is 34.2 and 34.3.
Yes.
Quoted. It must have been quoted.
Yes.
Para 13 and 14. Read para 13 and 14. 12, 13, 14.
Reading from para 12.
Yes.
The second question for consideration is where departmental inquiry has been instituted against an employee while in service and continued after attainment of age of superannuation, whether the punishment for dismissal can be imposed on on being found guilty of misconduct in view of the provisions of section
Just pause here.
34.2 of the CDA.
Pause here, please. Under 34.2, there is a provision that even after superannuation, the disciplinary proceeding can continue. Right? Next.
34.2 of the CDA rules provides that the disciplinary proceeding, if instituted while the employee was in service, whether before his retirement or during his re-employment, such proceeding shall be continued and concluded with the authority by which it was commenced in the same manner as if an employee had continued in service. There is a deemed fiction created by the rule concerning the continuance of employee in service during the departmental proceeding. The legal fiction is required to be given a logical effect.
So therefore, the disciplinary proceeding should commence while he is in service, and that can be continued beyond his period of superannuation. Next, para 14.
The rule 34.3 of the CDA rules provide of withholding a payment of gratuity during pendency of departmental proceeding and provides for recovery from gratuity of whole or part of the pecuniary loss caused by the employer in case of misconduct as provided under section 46A of the Payment of Gratuity Act. The Gratuity Act can wholly and partially be forfeited. Gratuity can be wholly or partially forfeited for as provided under section 46B if he is found guilty and the services are terminated for disorderly misconduct or act of violence or offence involving moral turpitude committed during the course of employment.
So therefore, these two rules are primarily talking of a disciplinary proceeding which was initiated while he is in service. Whatever be the ultimate
I
consequences.
opened my argument by saying that first, it was decided in Mahanadi Court is whether the departmental proceeding will continue and a person can be terminated.
So here is a case where the departmental proceeding has been taken to a logical end. Now I want to know, for the same allegation, merely because he has been convicted in a criminal case, can you initiate a departmental proceeding which was never initiated prior to that, right?
Perhaps also I was from the beginning.
Then can you read this para 47?
Yes. Thus, considering Rule 34.2 and 34.3 of the CDA rules, the inquiry can be continued giving a deeming fiction in such manner as if the employee continued in service and appropriate punishment including that of dismissal has been imposed apart from the forfeiture of gratuity only or part including recovery of pecuniary loss as the case may be.
So this is also talking of continuation of a departmental
Yes,
proceeding.
so I'm just
The point is whether a
This
fresh
was the
departmental
case,
proceeding
yes,
can be initiated.
There is no requirement of it. I'm just coming to it. Lordship in section 461 and 462. One is there has to be a departmental proceeding, finding of guilt and loss to be assessed. Two is he says if a person has been found to have committed an offence involving moral. Now, Your Lordship, this judgment says that whether a person can be dismissed post his retirement or not.
Provided the
a
disciplinary proceeding has been initiated.
Now, Your Lordship, 2022 judgment says that the same principle will apply to a criminal proceeding. Whenever inquiry word has been used, if Your Lordship substitutes it with the word criminal proceeding initiated while the employee in service and it continues post his retirement, if he is ultimately convicted.
Which is that paragraph of 2020?
Para 39 and 40. Your Lordship,
So yeah, we have to read it with para 30 also.
Lordship, para 30, Lordship said I had read out. Lordship, may I read out para
No,
30?
no, not required again. Now you have to read para.
39 and 40. Yes, 30 Lordship may distinguish it on the facts.
Yes,
But
certainly.
also law is-
Facts are important.
Yes. My Lordship, para 30.
Facts are
I
important.
am only assisting Your Lordship. Whatever
That's
also Your Lordship will be the final point.
No problem.
I am trying to
We are trying to understand.
Yes.
You see, we are
Yes, whatever
questioning.
I try to understand, I am trying to convey Your Lordship.
We see, I'm open.
No,
वो
I know
बंद
that.
करके आपका सब बात सुन के ऑर्डर कर सकते हैं तो आपको समझ
No, I
आए
know Your Lordship is open till the last minute and there it has happened in many cases
Yes.
that Lordship changed Lordship's mind even after reserving the judgment.
यस चलिए पैरा 46
Para 39.
ओके पैरा यस
We are of the view that principle as enunciated in Mahanadi Coalfields Limited would apply even though it is in context of a different set of rules. It would suffice to reproduce para 11, 11.2, 46, 47 of the said judgment as under. Which I am not reading out, Lordship had already seen those paragraphs. Lordship kindly come to Padapatti. We also believe that it is very restrictive view to disburse DCRG on the account of the proceeding against the petitioner coming to an end, even where the conviction has Lordship kindly marked this verse.
We also believe that.
We also believe
Yes.
that it is a very restrictive view to disburse DCRG on account of proceedings against the pensioner coming to an end, even where conviction has arisen. This is especially where convicted person has availed the remedy of appeal. An appeal is a continuation of the proceeding of the trial, and it would be thus a continuation of judicial proceeding. For example, if no appeal had been filed, then it could have been said that despite conviction in a criminal case, state is without authority in forfeiting DCRG or pension for that matter. If it is not so, we believe that the pendency of appeal cannot decentralize state from withholding DCRG, considering it as a hiatus period within which such certain arrangements have been made, which would be dependent on the outcome of the appeal. Here he was convicted, here the conviction trial is pending. So same principle also, if your lordship substitutes the inquiry with a trial for 462, your lordship may consider. For that lordship, no proceeding is required to be pending, or he should not be found guilty in a departmental proceeding.
So for the
462
same thing,
Yes.
you will have 3 proceedings.
There is no-
For the same thing, you will have 3
I
proceedings.
just explaining.
One is the departmental proceeding, which culminates during the period of his service. Other on the same set of facts, a criminal proceeding. And if he is ultimately terminated in the criminal proceedings, then under such circumstances, you will terminate him, irrespective of the result of the disciplinary proceedings. You want to say that?
I'm just trying to explain. Suppose there is a 3 proceedings. One, disciplinary proceeding, a person is exonerated. So just come to the extreme example so that I will be able to explain my case. One, he is exonerated, but for the same charges, criminal trial has been instituted, and he gets convicted. Irrespective of the facts involved in both the cases, if the conviction involves moral turpitude, you will be able to be terminated.
For that, you will have to initiate a proceeding, no?
Only a show cause that you have been terminated.
Show cause for termination has to be there,
Yes.
right? You will issue him a show cause that you have been convicted.
Terminated.
Now you are required to be
Yes.
terminated.
Now your lordship, so far as payment of gratuity act section 460.
No. We are talking about a third situation.
Third situation.
Where in a disciplinary proceeding he has been given a punishment.
Yes.
He has suffered that punishment, and a criminal case was pending, right? And he attained the age of superannuation. Right? You did not issue him any show cause as to why your services should not be terminated on conviction. There is no such show cause. There is no such
There is no
letter.
conviction.
So since there was no such conviction, do you want to say even after he attains the age of superannuation, you will give him a show cause treating him? Is there any law which says that as long as the criminal cases does not end, he is deemed to be in service? Is there any rule of that nature that if any criminal case is instituted against an employee, his employment is deemed to be continued?
Yes, that is what the honorable secretary paragraph.
No,
here.
deemed to be continued. You see, there is nothing deemed. You see, that is why this is important. Paragraph 30 is important because it was in this background it was decided that the disciplinary proceeding was to await the outcome of the criminal proceedings. In para 30, in this particular case, the disciplinary proceeding was to await the outcome of the criminal proceedings, isn't it? So that is why criminal proceeding was there, some appeal was pending, and then in the meantime he superannuated. So disciplinary proceeding was hanging, right? And once he was convicted, the management proceeded and dismissed him, irrespective of his superannuation. But here this is not the case. You could have waited. Had you waited, that let the criminal case be taken to a logical end, irrespective of, and we should not proceed with the disciplinary proceeding. The situation is very different.
Situation. Just to repeat, we initiate a departmental proceeding while of in service. We find him guilty, give him a minor punishment. Also, for the same charges, for the same fact, and I cannot say charges, for the same set of facts, criminal cases pending, wherein he while in service is convicted. For the same set of facts, he was given a minor punishment, and for the same set of facts, he has been convicted. So I put a question to myself whether he will be entitled to continue in service.
No, he will be dismissed
He will be dismissed
on account of
Why
his
also
conviction.
only because the criminal trial could not conclude while he was in service, and if he is dismissed, also automatically the
Show me
gratuity
any
will
rule that in spite of initiation of a criminal proceedings, if he attains the age of superannuation, he will be deemed to be in service.
Also, that is what you also section para 40 I was reading.
That is not the
I am reading a
we can't read it in isolation. We cannot
After
read
quoting
without
Dr.
section.
Mahananda, after quoting Mahanadi Coldfield in para 39, I was just trying to explain it. Yes.
The CBR rules is also quoted and taken care in, which says that independency of a departmental proceeding.
Yes.
That is the only word used, not a criminal proceeding, and departmental
That-
proceeding is concluded
Yes.
in this case.
So
And
I-
if the departmental proceeding has been written, end of justice meet by imposing such and such punishment. So, and that punishment, as you already should have known.
That is what the Honorable Supreme Court ultimately said in 22 that
You
we
see,
cannot keep a restricted.
Just tell me one thing. If a person superannuates, is there any legal bar in instituting a criminal case against him on account of defalcation while he was in service?
No, there is no.
Right? So if you initiate a criminal proceedings after his retirement, then also his you will get back his gratuity, etc.
Actually, I was asking the words which you also read from Mahanadi Coldfield. The departmental proceeding initiated while he was in service. When the departmental inquiry word has to be replaced in the 22 judgment which I was trying to replace, though factually there was difference, there was no department. That word departmental inquiry has to be substituted by criminal case.
It is not so strict.
Also, we can see para 40 once again. I'm slowly.
I have read it. Up orders.
These are.
Heard the learned counsels appearing on behalf of the parties.
And the amicus curiae.
With amicus and amicus. You have to say anything more?
One judgment under the judgment of the Supreme Court, on the basis of which again the division bench judgment, that is the judgment also wherein Jitendra Kumar Srivastava arising from this honorable court itself, wherein in fact in this particular matter the departmental inquiry and the criminal proceeding both were pending. Still the court held that you cannot withhold the gratuity amount. Para 15 onwards is
It was because the rules did not provide for it.
rules did not provide, and here also the rule says that the pendency of the criminal departmental proceeding, not the criminal proceeding, and that has been taken care in the matter itself, Your Lordship, in the appellate by the courts below, Your Lordship, that there was no departmental proceeding pending in this particular matter as per the rule states so.
You heard the learned counsels appearing on behalf of the parties. This petition has been filed challenging the order DT 27.04.2026 within bracket Annexure 4 passed by learned Deputy Chief Labour Commissioner within bracket Central Dhanbad, and also the order passed by the Appellate Authority under Payment of Gratuity Act in Gratuity Appeal number 20/2022 as contained in Annexure 7.
Yes.
As contained in Annexure 7.
7.
It is not submitted.
Annexure 3 and 4.
Annexure 3. 3 is the Appellate Authority.
No, 4 is the appellate.
As contained in Annexure
Annexure 3 is the original order and 4 is the appellate.
3 is the original order and 4 is the appellate order, whereby the appeal has been dismissed. The learned counsel for the petitioner, while giving the foundation fact, has submitted that the petitioner while in service was subjected to disciplinary proceeding as well as criminal case instituted by CBI. He then submits that the petitioner was held guilty in the disciplinary proceedings by order dated 28/5/2018 and a punishment was imposed of reduction to a lower stage in the time scale for 1 year without cumulative effect with effect from 1/6/2018. It was further observed that it will not operate to postpone future increment or affect the seniority after 1 year with effect from the date of penalty becomes effective. The learned counsel submits that there was an allegation that the measurement book was duly signed by the petitioner and it was evident that there was a shortage of coal more than 1,52,489 metric ton as per record as on 1/11/2009. And any irregularity done by the colliery surveyor in measurement book in which the petitioner had signed regularly, the responsibility lies on the petitioner as well. The learned counsel submits that on account of acts and omissions of the petitioner, acts and omission of the employee, the petitioner suffered financial losses. However, from the perusal of Annexure 1/1, there was no quantification of any financial loss suffered by the petitioner. He submits that the employee had filed a petition before the controlling authority alleging non-payment of gratuity as he attained the age of superannuation on 31st of January 2021. He submits that since the CBI case was instituted against the employee for the same set of charges and was pending before the criminal court, the petitioner was justified in not releasing the gratuity amount. The learned counsel has referred to the provision of Section 4 of Payment of Gratuity Act and has in particular referred to subsection 6 thereof to submit that the gratuity payable to an employee may be wholly or partially forfeited if the services of such employee have been terminated for any act which constitutes an offence involving moral turpitude, provided that such offence is committed by him in the course of employment. The learned counsel submits that since the criminal case involving moral turpitude while the workman was in service was pending, the petitioner was perfectly justified in withholding the payment of gratuity. He has then referred to the judgment passed by Honorable Supreme Court in the case reported in 2020/2018 SSC 71, Chairman cum Managing Director Mahanadi Coalfields Limited versus Ravindranath Chaubey, and has submitted that the same judgment was considered by the Honorable Supreme Court in the judgment reported in bracket 2022 bracket close 12 SCC 104, Secretary Local Self-Government Department and others, State of Kerala versus K. Chandran and others, and submits that it has been held that the principles as enunciated in Mahanadi Coalfield with regard to withholding of gratuity when the disciplinary proceedings are pending and during the pendency of disciplinary proceedings the employee retires, the same principle is applied in cases where the criminal case has been initiated against the pensioner initiated, but the conviction arises after his retirement. Okay? The Learned Counsel submits that since the order in the disciplinary in the criminal case would essentially relate back to his moral turpitude while he was in service, therefore the petitioner employer would be within their right to terminate the services, to dismiss the employee irrespective of his retirement, and consequently withhold the forfeit the gratuity. And this would be done in the view of section 4 within bracket 6 of the payment of gratuity. The Learned Counsel for the Learned Amicus, while opposing the prayer, has submitted that in the present case, disciplinary proceeding was taken to a logical end and punishment was imposed without quantifying any loss. And there was no occasion of continuation of the employee in service after superannuation merely because the employee, merely because a criminal case was pending. She has also submitted that no such order was also drawn that the employee would continue in service irrespective of his attaining superannuation on account of the pendency of the criminal case. The Learned Counsel has also, the Learned Amicus has also submitted that rules 34.2 and 34.3 were under consideration in Mahanadi Coalfields and also in the subsequent judgment as relied upon by the petitioner, which clearly indicated that the inquiry can be continued even after retirement by giving a grieving fiction that as if the employee had continued in service, an appropriate punishment including that of dismissal can be imposed, apart from forfeiture of gratuity wholly or partially, including the recovery of the pecuniary loss as the case may be. The Learned Counsel has then referred to the paragraph 30 of the judgment reported in brackets. 30 also. 30 is the fact. 30 of the aforesaid judgment reported in bracket 2022 bracket close 12 SCC 104 and has submitted that in the case before the Honorable Supreme Court, the state in their wisdom deemed it appropriate not to continue with the departmental proceeding though initiated and wait for the outcome of the criminal proceedings. The learned counsel has submitted that in such circumstances, the department would pass an order of dismissal irrespective of superannuation in the departmental proceedings.
In the department.
In the departmental proceedings. She has also relied upon the judgment passed by Honorable Supreme Court in the case of State of Jharkhand and others versus Jitendra Kumar Srivastava, and has referred to paragraph 15 of the said judgment. To submit that there was no statutory provision for withholding of pension or gratuity, and therefore the Honorable Supreme Court held that the gratuity could not be withheld during the pendency of departmental/criminal proceedings once the employee attained the age of superannuation. She has then referred to the judgment passed in WPS number 3987 of 2021, dated 16/5/2024, and has referred to paragraph 7, wherein the legal issue for consideration was as to whether pendency of criminal case would be a bar for non-payment of retirement benefits, including gratuity, pension, group insurance, and leave encashment. She submits that following the aforesaid judgment in the case of Jitendra Kumar Srivastava, it has been held that in absence of specific rule, the pension etc. could not be withheld. The said judgment has been upheld by this court in LP number 482 of 2024 by judgment pronounced on 25/8/2025. Yes, I referred to paragraph 31. 31 and 32. After hearing the learned counsel for the parties, this court finds that the petitioner was subjected to disciplinary proceedings and was given a punishment by order dated 28/5/2018. This is a minor punishment. Reduction, which is a minor punishment of reduction to a lower stage in time scale by 1 year without cumulative effect, with effect from 1/6/2018. And in the said proceeding, it was held that the petitioner or the present employee also had responsibility with coextensive responsibility with other persons who were responsible with respect to shortage of more than 1,52,489 metric ton of coal. On the same set of charges, admittedly the employee suffered the punishment and attained the age of superannuation on 31/1/2021. However, the criminal case arising out of the same set of charges continued, and the criminal case is said to be still pending. In the meantime, the employee filed the petition for payment of gratuity before the controlling authority, and the petitioner deposited the gratuity amount before the controlling authority and requested the controlling authority not to disburse the said amount to the employee. Thereby, the petitioner had taken steps so that no further interest could accrue on the payment of, on the liability to pay gratuity, but at the same time ask the controlling authority not to disburse the same amount. The controlling authority has, by reasoned judgment, refused to allowed the petition and directed that the respondent herein would be entitled to the amount of gratuity amounting to rupees 20,000, 20 lakhs, and the controlling authority relied upon the judgment passed by the Honorable Supreme Court in the case of State of Jharkhand and others versus Jidhesh Kumar Srivastava, which has been referred to by the learned amicus. The appellate authority also considered the appeal and also considered the specific argument of the management that in the judgment passed in the case of Mahanadi Coalfields Sutta, the Honorable Supreme Court has held that in view of Rule 34.3 of CDA Rules 1978, the employer had a right to withhold gratuity during pendency of disciplinary proceedings.
That was the judgment referred to the referring judgment.
Sorry?
That judgment it was referred to the larger judge. Manadi Coalfields, final judgment I had shown to you. The judgment which the controlling authority has referred was the judgment of referral.
And the
Therefore, the final judgment larger than judgment. That was referred because the Honorable Court was of the view that judgment saying guilt is not a good law, therefore it was referred for reconciliation.
okay, and ultimately it has been held that Jaspal is not a good law.
Yes, in this para particular.
During the course of hearing, it has been pointed out by the learned counsel for the petitioner that the earlier view taken by the Honorable Supreme Court in the case of Jaswant Singh Gill has been held to be no longer a good law in the judgment which was finally decided in the case of Mahanadi Coalfields, which is reported in
2020 volume 18 SCC page
2020 volume 18 SCC page number
71.
71. The appellate authority ultimately held that the appellate authority referred to the order judgment of Jaswant Singh Gill versus BCCL, wherein it was held that power to withhold penalty gratuity or not. Power to withhold gratuity contained in Rule 34.3 of the rules must be subject to the provision of the Act, and the gratuity becomes payable as soon as the employee retires.
That part both the authorities have heard, relying on just one single. By that time it was already over. 22 order.
Okay. This court finds that in the this court finds that it is not in dispute. In the case of Mahanadi Coalfields, the impact of Rule 34.2 and Rule 34.3 have been mentioned in paragraph 12, 13 and 14, which is quoted as under. The FOC rules clearly provide that under Rule 34.2 of the CTA rules, disciplinary proceedings shall be continued and concluded by the authority as if the employee had continued in service, and there is a deeming fiction created by the rule for continuation of the employee's service during the departmental proceeding. And the legal fiction is required to be given to a logical end. And Rule 34.3 clearly provides for withholding of payment of gratuity during pendency of disciplinary proceedings, and provides for recovery from gratuity of the whole or part of the pecuniary loss caused to the employer in case of misconduct as provided in section 46 A of the Payment of Gratuity Act. In case it also provides that the gratuity can be wholly or partially forfeited as provided in section 46(4)(6)(b) in case the employee is found guilty and services are terminated for disorderly misconduct or act of violence or offence involving moral turpitude committed during the course of employment. The judgment passed in the case of in paragraph 39 of the said judgment, the earlier judgment passed in the case of Jaswant Singh Gill has been considered, wherein it was held that even if the disciplinary inquiry was initiated before attaining the age of superannuation, if the employee attains the age of superannuation, the question of imposing a major punishment by removing or dismissal from service would not arise. Paragraph 39 is quoted as under. The Honorable Supreme Court, in the case of Mahanadi, found it difficult to agree to the decision of the Jaswant Singh Gill and held that the rules were not repugnant with the provisions of Payment of Gratuity Act, and the validity of Rule 34.2 or 34.3 could not have been decided in the case of Jaswant Singh Gill, as the same were not under question. The Honorable Supreme Court cited reasons for not agreeing with the judgment passed in the case of Jaswant Singh Gill in paragraph 41. And the reasons are cited are as under. Paragraph 41 को quote करेंगे. And ultimately, the Honorable Supreme Court came to a finding in paragraph 46 and 47. As follows. 46 and 47.
42 they have overruled it.
Okay.
1 line paragraph.
That's right. Yes. By paragraph 42, the Honorable Supreme Court overruled the decision passed in the case of Jaswant Singh Gill. Right? This court finds that the judgment in the Mahanadi coalfield overruling the judgment of Jaswant Singh Gill was certainly not brought to the notice of the controlling authority as well as the appellate authority, who have passed the impugned judgments. However, the counsel for the petitioner has also relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2022 bracket close 12 SCC 104. Sorry, you go. No, no problem.
para 39 and 40 of 2022 we relied on.
Wherein it has been held in paragraph 39 and 40 that principles enunciated in Mahanadi Coalfields would apply even though and the Supreme Court has reproduced para 11 and 11.2 and 46 and 47. Paragraph 40 is also quoted as under. Your senior never cited it. In the midst of the dictation, you start citing sentence. What is it?
Under 17, the issue was during the pendency of the criminal proceeding, whether the gratuity can be withheld or not. Para 17 is the conclusion reporting it.
The learned counsel has also relied upon the judgment. This has not been subject matter of appeal. This has not been subject matter of appeal.
The here, the subject matter is that
No, this was not subjected to appeal. The learned counsel has also relied upon the judgment passed by this court reported in 2019 SCC Online JHAR 3202, decided in WPL number 4233 of 2018, and has submitted that the state judgment has already attained finality. And in state judgment, in paragraph 17, it has been held that if a criminal case has been instituted during the service life involving moral turpitude, then the employer has a right to withhold the amount till the conclusion of the criminal trial. And if the criminal trial results into conviction of the employee, then the gratuity amount stands forfeited. And if he gets acquitted in the criminal trial, then he is entitled to receive the entire gratuity amount along with interest. Paragraph 17 is quoted as under.
LPA is also there. 671
678.
71 of 2019.
671 of
2019.
2020. However, during the course of hearing, it transpired that an LPA has been filed against the state judgment numbered as LPA number 671
671 2019.
2019. Admitted? Admitted?
There's some problem on this side also. Earlier also I checked, that time also it was not. The connection failed. I will update you.
But there is a 671 of 26 to 2019. 2010
2019.
19
2019.
disposal
Yeah.
दिखाइए order दिखाइए
Dismissed as withdrawn. Final order was passed on 25/1/2021. Dismissed and withdrawn. The smaller, the summary of the judgment is the main judgment is not.
It has been pointed out that the appeal filed against the said judgment was withdrawn. Is there any reference of any disciplinary proceedings? Nothing. There is no such reference.
Payment of statutory act में competent authority के पास है and thereafter appellate authority.
In the present case, this court finds that
No mention of any disciplinary proceedings.
in the judgment passed by coordinate bench of this court reported in 2019 SSC online JJR 3201, there is no reference of any disciplinary proceeding instituted against the employee, if any. Further, from paragraph 17 itself, it appears that the employee would be entitled to gratuity with interest if he is ultimately acquitted in the criminal case with statutory interest. However, in the present case, it has transpired that the petitioner has deposited the entire gratuity amount before the competent authority, and in view of section this is statutory interest. Statutory interest this may. Payment of gratuity. There is a statutory interest. Section 7, 3A. The statutory interest is payable under Section 7 within bracket 3 capital A. Which clearly provides that if there is any delay in payment of there is a clear provision that no interest is payable if the delay in the payment is due to the fault of the employee and the employer has obtained permission in writing from the controlling authority for the delayed payment on any ground. Subsection 4A also provides that if there is any dispute as to amount of gratuity payable to an employee under the Act, as to the admissibility of any claim, or in relation to an employee for payment of gratuity, or as to the person entitled to receive the gratuity, the employer shall deposit with the controlling authority such amount as he admits to be payable by him as gratuity. During the course of hearing, it transpired that once the amount of gratuity was deposited before the court, before the authority, the petitioner would not be liable to pay further interest from the date of deposit. Here is a case where the petitioner has not exercised the power to withhold the payment of gratuity. Rather, it is a case where the petitioner has deposited the admissible amount before the authority, still requested the authority not to pay the amount.
Subject to the outcome.
No, why? You should have said, I will not pay. Because now he will not be entitled to interest, even if he is acquitted after 20 years. Who will pay for that? Right? In the present case, this court finds that the petitioner, having failed to, in the present case, even if it is assumed for a moment that the petitioner was still entitled to withhold the gratuity amount on account of pendency of the criminal case, the petitioner did not exercise the power to withhold the amount with them. Rather, they had deposited with the authority. If the employee is ultimately acquitted, then under such circumstances, the petitioner would not be liable to pay interest as the amounts have stood deposited before the controlling authority. This court further finds that in the judgment reported in bracket 2022-12 SCC 104, in paragraph 30, it has been, the facts of the case has been mentioned, wherein it has been recorded that the state in its wisdom, though initiated the departmental proceeding, but deemed it appropriate to await the outcome of the criminal proceedings. And the result of such a course, as per the Honorable Supreme Court, was that this would mean that the state would still be empowered to dismiss an employee from service based on conviction in the criminal case. And the state cannot have an opportunity to have a separate disciplinary proceeding even if acquittal takes place. The Honorable Supreme Court observed in that case that it was the choice of the state government as to whether they would like to hold separate departmental proceeding or to go by the final view of the criminal court. And the latter was naturally based not on preponderance of probabilities but on proof beyond reasonable doubt. And it was the latter course which the state had followed in the same case. In the present case, the petitioner had followed the course otherwise. They had initiated the disciplinary proceedings, which ended in a punishment without any quantification of the loss suffered, and the criminal case has been. Under such circumstances, there was no scope for the petitioner to exercise any power of continuation of disciplinary proceedings pending criminal proceedings. And consequently, this court is also of the view that once the employee had attained the age of superannuation, for the same set of allegations, there was no scope to initiate a fresh departmental proceeding in order to dismiss the employee on the ground of moral turpitude having been convicted in a case. Such a course is not contemplated in the rules. We are in 34 number 34.2 and 34.3 as mentioned above. In such circumstances, although the authorities have not taken note of the fact that the Jaswant Singh Gill's case was overruled in Mahanadi coalfields, the same by itself is not sufficient to set aside the impugned judgment, the impugned orders in view of the aforesaid facts and circumstances. Consequently, this petition is dismissed. There will be a lot of corrections because ये बीच में एक आप कहानी घुसा दी.
And I was continuously trying to open. It was not, the site was not opening.
Just one strike that the rule also says that the proceeding, departmental proceeding should
That
be
is
made.
why. That is why. It is very, very clear that it was no such rule was pointed out by the counsel for the petitioner that
They have quoted that rule in
वो
paragraph
rule का
32.
तो ठीक ही है. Disciplinary proceeding should be
Proceeding होना चाहिए. That is written that during the pendency of the disciplinary proceeding, the gratuity amount can be paid. That is not there in this case.
आज का फाइनल डिस्पोजल का 2 मैटर्स और बाकी हैं. We'll take it up tomorrow because I have read the file. अब बार-बार नहीं पढ़ेंगे.
Next.
Sorry.
Next was
क्या था उसमें भूल गए. क्या है?
उसमें regularization का. They could not produce any document from it.
We'll post it tomorrow. है ना. उसके बाद वाला कौन सा है? आपका है. कितना टाइम लगेगा आपके केस में? हाँ? बाकी कोर्ट ही जानता है कितना
Two
टाइम
rounds, it has come after 2 rounds. After an order of remand by this court, again the order has been passed.
We'll take it up tomorrow. Both these matters. These matters, the matter could not be taken up. One sir. Tomorrow there is a partnered matter also, right? After that partnered matter we'll take up. Sorry? Third be partnered. There are 2 partnered matters, right? After that, if time permits, we'll take it up. Madam, in which case are you? आपको देख के हमको लगता है कि I am guilty of not taking up your case.
I am happy that the matter and thanks to for getting I am present.
Serial 17th है ladies.
17 का क्या है?
आइए जो था.
आइए हाँ. Where is that IU who's for the other side? Yes, madam, are you there? Okay, IU has been filed. Any objection? Any objection?
That is the IA number 1522 of 2025.
IA number 1521 of 2025.
Para 6.
The learned counsel for the petition respondent has referred to paragraph 6 of the interlocutory application. Not before me.
What is serial number 9? What has happened? The step of notice has been taken after lapse of the period which is mentioned in the document.
Serial number?
9.
You never mentioned it at 2:15.
I can
Right. Sir, अब आप बार काउंसिल के मेंबर बन गए, आपको तो लेट नहीं आना चाहिए. आपका लेट हम माफ नहीं करेंगे. लाइक सीरियल नंबर 9. आपको सबसे ज्यादा वोट मिला है. मेनी कांग्रेचुलेशंस. अब बताइए सर, इसमें क्या करना है?
इसमें ऑफिस रिपोर्ट दैट द इन कंप्लायंस ऑफ ऑर्डर डेटेड 29/10/2025 step has not been taken within 2 weeks but has been step has been taken on 6/2/2026.
FA number 162 of 2025. As per the office note, it has been pointed out by the counsel for the petitioner that as per the office note, the steps for service of notice upon the respondents whose speakers could not be taken within the stipulated time granted by the order dated 29th of October 2025. He submits that the refuses have already been filed. An appropriate order be passed so that the notices be dispatched. Considering the aforesaid submission, office is directed to dispatch the notices already filed in terms of order dated 29th October 2025, though belatedly, fixing the next date of hearing as 8th of June. Office to track speak post